Welcome everyone to this EU settlement scheme training on people with criminal convictions. I'm Bella, Joint CEO of Here for Good, and I'm also an immigration lawyer.
And I'm Carla, I'm Here for Good's volunteer coordinator, and I'm also an immigration lawyer based at Bindmans.
So firstly, an introduction to Here for Good. Here for Good is a legal charity which exists to provide free immigration advice to EU, EEA and Swiss citizens and their family members living in the UK. We primarily assist those most in need of free immigration advice, such as the elderly, homeless, victims of domestic violence and trafficking, people with complex needs, and people in financial hardship. Our services include an email and telephone advice line, complex casework done by our members of staff, and we also have a network of volunteer lawyers who are taking on pro bono cases across the UK. And an introduction to this training programme. This training is commissioned by the GLA and delivered by Here for Good. We are conducting 16 EU settlement scheme training sessions between June and October 2020. These include this specific criminal records training, as well as other specific trainings, and also an overview of complex cases training. This training is designed for OISC Level 1 advisors, OISC Level 2 or 3 advisors who do not regularly advise on the EU settlement scheme, and individuals providing frontline support to vulnerable persons. It is worth noting that this training is not designed to replace official OISC training, and also that while Carla and I are experts in immigration law, we are not experts in immigration regulation. And so if you are OISC accredited but unsure what work you can do at your level, we would recommend contacting OISC directly. The contact details of OISC and also other regulators are provided in our training manuals that will be sent to you after the session. I'm now going to pass you over to Carla, who will discuss the training objectives for today.
Thank you, Bella. So the aim of these training sessions are two main objectives. The first one is to provide you with an overview of the main issues that you might encounter when assisting persons with criminal convictions to make applications under the EU settlement scheme. And secondly, we will also provide you with practical tips in order to best support persons with criminal convictions with the applications under the EU settlement scheme. The structure of the training is as follows. So first, we're going to provide you a brief overview of the EU settlement scheme. Then we will discuss suitability and criminality issues under the EU settlement scheme. We will then talk about working with persons with criminal convictions. And we will also discuss common issues that arise in cases involving persons with criminal convictions. Finally, we will go through a few case studies together to apply everything that we have learned in the training today.
So before we go into the main section of this training, we're just going to give you a brief overview of the EU settlement scheme. We are aware that some of you may have already have a good understanding of the information covered in this section. However, as we have people of different levels of experience attending, we think it may be beneficial for some of you to have a refresher of the EU settlement scheme. This brief overview will cover the legal background and framework, who needs to apply under the EU settlement scheme, the relevant deadlines, key requirements for settled status, and an overview of the application process. I should note that section 1 to 2 of the training manual, which will be provided after the session, give a much more detailed overview of the EU settlement scheme. They also provide a step-by-step guide to the application process. Please therefore refer to these sections of the manual after the session if you need to familiarise yourself further. So firstly, we're going to look at the legal background and framework behind the EU settlement scheme. So the legal background, as we all know, is essentially Brexit. On the 31st of January 2020, the UK officially left the EU, and the withdrawal agreement between the UK and EU was implemented into UK law as the European Union Withdrawal Agreement Act. As we all know, the UK is currently in a transition period, which is due to last until the end of this year, the 31st of December 2020. From the 1st of January 2021, as far as we understand, a new points-based immigration system will apply. To understand the EU settlement scheme, it is important to be aware of both EU law and domestic law. Under EU law, the rights of EU, EEA and Swiss citizens and their family members come from something known as the Free Movement Directive. the Free Movement Directive was implemented into domestic law as the Immigration EEA Regulations 2016. As a result of the Withdrawal Agreement, Appendix EU was implemented under UK law. Appendix EU is the legal framework behind the EU settlement scheme. Currently, these legal frameworks coexist. However, the EEA regulations will be repealed, most likely at the end of this year. It is important to note that this will directly affect those applicants who cannot apply under the EU settlement scheme until they have been granted a document under the EEA regulations. We will discuss this more later on. So, in terms of the EEA regulations, it is good to have at least a basic understanding of these. As you may know, under the regulations, an EU, EEA or Swiss citizen has an initial right to reside in the UK for 3 months. To continue to reside, they will then need to be considered a qualified person. To be a qualified person under EU law, you must be exercising treaty rights, which includes working, studying, being self-employed, being self-sufficient, and looking for work. After 5 years of exercising treaty rights, a person will automatically acquire the right of permanent residence under EU law in the UK. Under the regulations, EU citizens can also have certain family members join them. There are various different documents which you can apply for to confirm your rights under EU law. These will be discussed later on. And as I just noted, due to Brexit, all of these documents will cease to be valid after the 31st December 2020. Those who hold them must therefore still apply under the EU settlement scheme. So now looking at Appendix EU. As noted, Appendix EU has been developed as part of the Withdrawal Agreement. Appendix EU is the legal framework for the EU settlement scheme. As we all know, the EU settlement scheme is a mechanism through which EU, EEA and Swiss citizens and their family members can apply to secure their rights in the UK. At present, this runs parallel to those EEA regulations 2016. As I'm sure you're all aware, there are 2 types of status that can be granted under the scheme. These include indefinite leave to remain, also known as settled status, for those who have lived in the UK for 5 years or more, and limited leave to remain, also known as pre-settled status, for those who have lived in the UK for less than 5 years. So what is the difference between the EEA regulations and Appendix EU? So the main difference between these is that under the EU settlement scheme, the main requirement is residence in the UK. There is no need to demonstrate that the applicant has been exercising treaty rights. The applicant just needs to have been resident in the UK. It is also worth noting that under the EEA regulations, the right to reside is acquired automatically, whereas you must apply for status under the EU settlement scheme in order to obtain residency rights. This next slide shows the different documents issued under the EEA regulations and the EU settlement scheme. It is important you're aware of the documents issued under the EEA regulations, as you may have come across people with them in your work, and as discussed later, they are required for some EU settlement scheme applications. Also, due to Brexit, as I've noted, these documents will cease to apply after the end of this year. Those with these documents must therefore apply under the EU settlement scheme. This table is also provided in our comprehensive training manual, so you can refer to it later on if you need to. So now we're briefly going to discuss who must apply under the EU settlement scheme. So, as I'm sure you know, EU, EEA and Swiss citizens and their family members need to apply under the scheme. This includes people who have been issued with documents under the EEA regulations, even if, for example, they've been issued with a permanent residence document. Exceptions to who need to apply under the scheme include Irish citizens, British citizens, including those who have dual citizenship, and individuals who have already been granted indefinite leave to remain or indefinite leave to enter under the UK immigration rules. So on that last point, on individuals who have been granted indefinite leave to remain or indefinite leave to enter under the UK immigration rules, it's worth noting that while they do not have to apply under the scheme, they may want to do so. This is because if they apply for settled status, They will receive an up-to-date proof of their status. They will have better family reunion rights, in which status under the EU settlement scheme is required. They will be permitted to leave the UK for 5 years without losing their indefinite leave to remain status, whereas if you have indefinite leave to remain issued under the UK immigration rules, you will lose your status after 2 years of consecutive absence from the UK, and they will avoid the potential consequences of being unable to easily evidence their right to reside in the future, as we all saw with the Windrush scandal. In terms of non-EEA family members, there are 2 categories who qualify under the EU settlement scheme: direct family members and extended family members. In terms of direct family members, you have, as shown on the table, spouse, civil partners, direct descendants under 21, so for example, children or grandchildren under 21, dependent children over 21, and dependent persons in the ascending line, so for example, dependent parents or grandparents. In terms of extended family members, we have the groups shown on this table, which includes durable partners, so that's unmarried partners, usually those who have lived together for 2 years, and other types of dependent relatives or members of the household in need of the EEA citizen's care. The primary difference between direct and extended family members that is important for you to know about for the purposes of the EU settlement scheme is that extended family members have to hold a document issued under the EU regulations in order to apply under the scheme. There are other categories of non-EEA citizen family members who may also be able to apply under the EU settlement scheme, including those with certain types of complex cases. These will be covered by me later on in the training. And I'm now going to pass you on to Carla, who's going to discuss deadlines.
Thank you, Bella. I'm just going to make myself present a second. Okay, great, thank you. So the deadlines under the EU settlement scheme. The main deadline is the 30th of June 2021, which is the end of the grace period. This is except for a few cases. And this deadline applies to applicants who are resident in the UK by the 31st of December 2020, which is the end of the the end of the transition period. That means that at the moment there is some time pressure for certain groups of applicants who have to apply first under the EEA regulations 2016. So, as Bella described earlier, extended family members like durable partners, they must hold first a residence card issued under the EEA regulations before they can apply under the EU settlement scheme. Therefore, for this group of applicants, there's now time pressure to apply before the end of this year because the EEA regulations will be repealed by the end of this year. Now we can go through the key requirements to apply for settled status. The key requirements are as follows. First one, it would be 5 years continuous residence in the UK. Secondly, no supervening event has occurred in the case. And thirdly, the applicant must meet all the eligibility and also the suitability requirements. Now, continuous residence means that the applicant cannot be outside the UK for more than 6 months in any 12-month period of the 5 years qualifying period. This becomes very important for those who have pre-settled status. But if in the future they want to upgrade to settled status, they need to take into consideration the maximum permitted absences for each 12-month period. Although this is the general rule, there are some exceptions. For example, when there is a single period of absence of more than 6 months, but which does not exceed 12 months. And because the absence has happened for an important reason, such as study, childbirth, or vocational training. The no supervening event has occurred is another requirement to apply under the EU settlement scheme. The Home Office defines supervening event in Appendix EU as follows. First, a period of absence from the UK of more than 5 years, or of 4 years if a Swiss citizen, since they last acquired the right of permanent residence in the UK, whether they have applied for the document or settled status. It's also a supervening event when the applicant has been issued with an exclusion or deportation order under the regulations or other than under the regulations, meaning under the immigration domestic legislation and not under EU law. Suitability requirements. We said earlier that another key requirement under the EU settlement scheme is for applicants to meet all the eligibility, but also the suitability requirements. Now, those are considered in Appendix EU 15, which are the mandatory grounds of refusal, and EU 16, which are the discretionary grounds of refusal. We are going to discuss about this more about the mandatory and grounds of refusal a bit later on in the training. Overview of the application process. Well, we're going to give you now a very quick overview because we understand that most of you might be familiarized already with the application process, but just as a refresher. So there are three main checks in all EUSS applications. First check is to check the applicant's identity and nationality checking. This, for those who have a biometric passport or ID or have also a biometric residence card, can be done on the phone. Otherwise, it can be done the application online, and then the applicant can send their passport or their passport or ID to the Home Office. Or otherwise, those who do not have identity or nationality documents, they can request a paper application form. Now, the second check is the residence checking, which is done automatically through the Home Office checking applicants' HMRC and DWP records. And thirdly, the criminality checking. The identity and nationality checking, as I just mentioned, for those who have valid passport or national identity card, that should be enough. Europeans need those documents, so passport or national identity card, but non-EEA family members, they can also provide their biometric residence card issued under the EEA Regulations 2016. As explained, for those who have a biometric relevant document, they can apply using the EU Exit ID Document Check mobile app, which is available for iPhone and some iPhone and Android phones. For those who have a document that is biometric but do not have the technology required to scan the passport, for example, they don't have one of these phones who accept this mobile app, they can also go to one of the locations offered by the Home Office to do document scanning. If for those who do not have passport or ID, which is biometric, they can complete the application online and they can also post the passport or ID to the Home Office. And there is an extra requirement for non-EEA family members, which is also as part of the application process, to book an appointment with Soprasteria to enroll their biometrics. Resident checking, as I said earlier, is automatically confirmed by the Home Office by checking applicants' HMRC and DWP records. However, if those records do not show a continuous residence of 5 years and the applicant confirms to you that they have been living in the UK for 5 years or more, there's also a possibility that they can also upload documentary evidence to show the residence in the UK. It's worth noting that there is some preferred, alternative, and unacceptable evidence, and you can find a list of what is in each category in Annex A of the Home Office guidance. Criminality checking. Well, applicants who are age 18 or over are all required to disclose the criminal records, and the problem is that failure to do so might potentially trigger refusal on grounds of deception. In any event, all applications are also subject to checks against the Police National Computer, the Warning Index, and also overseas criminal records checks. That means eventually that some people with criminal records might be turned down for settled or pre-settled status as a result of that criminality checking and on grounds of suitability. Paper application form is another route in which applicants can also apply under the EU settlement scheme. Paper application form normally applies for European citizens or family members who do not have a valid ID or passport, and also for some non-European family members who are applying under specific categories, and those are surrendering, derivative right of residence, and also family members of dual citizens, also called as loans case. In those cases, those who fall under one of these categories and need to apply under paper application form, they can call the EU Resolution Centre and basically ask for a personalized application paper form, and then they will have to complete it, put all the documents together, and post it to the Home Office. Processing times. The latest guidance, which is published, I believe, in May 2020, says that it takes around 5 working days for a straightforward application to be processed, but it can actually take up to a month. Processing can take longer than 1 month, according to the guidance, if, for example, further information is requested, the applicant is a minor and the application is not linked to an adult, the applicant has applied through a paper application form, the applicant has criminal records, or we're talking about a non-EEA family member who is applying based on a relationship that they have never realized before on a previous application with the Home Office. Even though the guidance stipulates these specific processing times, in practice, we are seeing major delays under the EU settlement scheme. Now, if the delay is longer than 6 months, it might be possible to challenge it via a judicial mechanism called judicial review. And prior to that, solicitors will normally prepare a pre-action protocol letter, setting out why this delay could be unreasonable, unlawful in the case, and what's the detriment that is causing to the applicant. That means that not all delays might be challengeable, but if you have a client who has been experiencing a massive delay for at least more than 6 months, and they are suffering a detriment as a result, and they're struggling, and there is no reason why the application should be delayed, it might be possible to challenge it. It might be that you don't have the accreditation to do this type of work, but you could also refer to a more senior immigration advisor or to other charities who might be able to help. At Here for Good, we have some capacity sometimes for challenging delays, so feel free to also reach us in case you have a client in this situation. Well, getting a decision. So this is normally what happens at the end of all the applications, at the end of the application process. Normally, the application is approved, and in those cases, the applicant will receive a letter by email confirming that the application has been approved, or if they have applied by post, they will receive a letter by post. Now, this letter or email that they receive is not proof of the immigration status. That means the applicants need to view and prove their rights in the UK of settled or pre-settled status online. And this is because the EU settlement scheme is a digital system and applicants are not given physical proof of their immigration status in the UK unless they are non-EEA family members. So those the non-EEA family members without already BRPs issued under the regulations are the only category of applicants that are actually given a residence card under the EU settlement scheme. So because we're talking about a digital system and the importance of viewing and proving your rights online, it's also same important to keep updating details. So all the details provided when the applicant applied, such as the phone number, the email address, the home address, and the passport number, if any of those details change, it is important to update the Home Office, and this can be done quite easily online. Now, in certain instances, applications may be refused. Now, there is a few remedies against those refusals. There is a right of appeal for those applicants who made an application on or after 11 p.m. on Brexit Day, on the 31st of January 2020. And for those who applied before, they do not have a right of appeal. However, they still can lodge an administrative review. This applies to those who appeal on or after or before Brexit Day. And in any event, before the deadline, all applicants can also submit fresh applications. Losing a status, yes. So EU settlement scheme, like settled status or pre-settled status, can be lost in some situations. So, for example, those who have been granted settled status, that immigration status can be lost if then the person has spent 5 years or more abroad consecutively, okay? And will be 4 years for Swiss citizens. And also, and again more relevant for this training, subsequent criminal offending might lead to a revocation of indefinite leave to remain or settled status. With pre-settled status, the absences that are allowed before you lose the limited leave to remain is 2 years, so 2 years consecutive years, as we just mentioned before. But again, be careful with the 6 months maximum limited permitted absences in each 12-month period. And pre-settled status will also be lost kind of automatically if the person do not apply for settled status before the expiry date of the decision, that do not apply under the EU settlement scheme or under another immigration route. But if it's not converted, it will be lost as well after 5 years. Okay, so suitability and criminality under the EU settlement scheme. So we're going to now talk more about what the guidance say and how do we approach those kind of cases. And these are the kind of 8 points that I'm going to be covering now, quite briefly, each of them. So the withdrawal agreement, what are the suitability requirements under the EU settlement scheme? We're going to explore which are the mandatory and the discretionary grounds of refusal, the requirement of self-disclosure that all applicants have, and also the automatic checks against the police national computer, referrals to immigration enforcement, overseas criminality, which also is relevant for this type of application, pending prosecutions, and decisions to refuse on suitability grounds. So, the withdrawal agreement. This slide is just to put you in context of where these suitability grounds come from, which is the power, which is the legislation that allows the Home Office to create a scheme where suitability is part of the requirements, basically. So all of this, we can find it in Article 20 of the withdrawal agreement. So Article 20 sets out the circumstances when it might be appropriate to restrict the right of entry or residence of an EU citizen, as well as a family member, or any other person which is also protected under the withdrawal agreement. Now, there are also corresponding arrangements for citizens from the EEA and EFTA states, okay? So, Article 20 of the withdrawal agreement basically sets out the following. It says, 1, the conduct of citizens, conduct meaning criminal conduct of citizens which are covered by the withdrawal agreement, and before the end of the transition period, will be considered in accordance to the European directive, which has been then transposed into domestic law under the EEA regulations 2016. Okay, so that mainly means that those who have criminal convictions, and this criminal conviction, and those persons are protected by the withdrawal agreement, and those criminal activity happened before the end of the transition period, that criminality will be assessed according to European law. Now, for criminal conduct that of those European citizens or other people covered by the withdrawal agreement that happen after the end of the transition period, that criminal activity, that criminal conduct will be then assessed under the national legislation on deportation, which is much more restrictive than European law. So there is a major change here when the criminal conduct happens, whether it is before or after the transition period, at the deportation threshold that will apply for one or the other. So, what are the suitability requirements under the EU settlement scheme? As I said earlier, those are regulated in 15, 16, and 17. And basically, Appendix EU set out the basis on which an application under the Appendix will, mandatory, or may be refused. The Home Office guidance, of course, you might be aware that there is a specific guidance on suitability issued under the EU settlement scheme, states the following. States that the assessment of suitability must be conducted on a case-by-case basis, so it has to be case-by-case. It has to be based on the person's personal conduct and circumstances in the UK, as well as overseas, including whether they have any relevant prior criminal convictions. So they look at criminality in that sense become important when it comes to suitability. So does this person have any prior criminal convictions in the UK or overseas? And also, and sometimes people forget about this, but it's important to remind, and whether they have been open and honest in their application. And here's when this requirement of self-disclosure become important, because we don't want people being refused because they have not been honest in disclosing the criminal convictions, for example. So, looking at the mandatory grounds of refusal, those are in EU 15. And it basically says that an application under Appendix EU will be refused on grounds of suitability, and this is will, mandatory language, where at the date of decision, the applicant is subject to deportation or exclusion decision. So if you have an applicant that is given a deportation or the exclusion decision and is still valid and enforced, the application will be refused. So the priority for that applicant is to actually go and challenge that deportation exclusion decision rather than applying under the scheme because it will be refused. Now, it's worth noting as well that EU 15.2 talk about the UK islands, and these the UK islands meaning, well, all the islands that you see at the end of these slides at the bottom, so Isle of Jersey, Isle of Man, etc. And Appendix EU seem to say that those who are living in those islands and they have a deportation or an exclusion decision, in those cases, the application may be refused. So it's not using a mandatory language. It seems to be more grounds of discretion if those activities and those decisions have been issued in those jurisdictions. Okay, so just something to point out in terms of drafting Appendix EU. So what is a deportation order? Of course, if we're saying someone who has been given a deportation exclusion order will be refused automatically, we need to understand what a deportation order is. It's not really the aim of this forum now to talk about deportation law, which is very, very complex, and it will take us like hours to go through. But I just wanted to point out that it's basically an order made under the Immigration Act by virtue of the EEA regulations if it's made under EU law, okay? And it normally is a decision normally justified on the grounds that the person's removal from the UK is justified on grounds of public policy, public security, or public health. So we're talking about serious offender, persistent offenders, etc. Okay? Here again, there is a bit more explanation about what a deportation order is, but at the end of the day, this slide re-emphasizes what I just said earlier, that it's very important to understand that when advising clients, that those who commit criminal offenses before the end of the transition period, that criminal offense will be assessed in light of EU law, and those who commit criminal offenses after the specified date they call it, but this is a transition period, they will be assessed under UK domestic legislation on deportation, which is much more restrictive, and the thresholds are less protectionist of as they are in EU law. Okay, so this is all I wanted to cover on deportation. Now, this slide, unfortunately, I think is a repetition a bit of the same. So, yeah. Now, discretionary grounds of refusal, they are in EU 16. Now, they are discretionary, means that we can make representations, we can fight for those to not be applicable, and for the applicant to be granted settled or pre-settled status. So the Home Office may refuse on those cases on grounds of suitability if one of those have happened. But again, the test here is that the Home Office needs to show that it is proportionate to refuse on those cases. It's not mandatory. It has to be proportionate to refuse. And this is basically when an applicant, for example, has submitted false representations to the Home Office or fraudulent, for example, a fake ID, or they're claiming to be the spouse of someone, of an EU national when they know that they are not the spouse or they don't have any relationship. So false or fraudulent representations have been submitted, or when the applicant is subject to a removal decision on the grounds of misuse of rights, or when the applicant has been previously refused admission, or the EU settlement scheme has been cancelled, or when the relevant is a relevant excluded person. So these are the discretionary grounds of refusal. Again, we might be able to make representations for them to not apply. The first one, false or fraudulent representations, I already covered what it is a little bit, but it's basically one aspect that is important about this grant of refusal is what it says in the first bullet point, applies whether or not to the applicant's knowledge false or misleading information, representations, or documents have been submitted. So it's important for the applicants to know what is happening in the application and to have complete control on the application under the scheme, because if false representations have been submitted and the applicants had someone helping and the other person has submitted these false representations, that doesn't excuse the applicant. So it's important that point. Also, includes, as I said here, false or misleading information submitted to any person to obtain a document used in support of the application, and the information or this representation is submitted by the applicant has to be material for the decision. Okay, so these are the parameters to look at these discretionary grounds of refusal. And practical examples that we might find would be, providing false documentation, falsely declaring that the person is entitled for settled status when they know that they haven't been living here for 5 years, falsely claiming a family relationship or dependency when it's not existent, or retained right of residence, and of course providing false documents as identity or nationality documents. Another discretionary grounds of refusal that we might see at some point are applicants who are subject to removal decision on the grounds of misuse of rights, and that, for example, could be an applicant who is seeking to enter the UK following an administrative removal, and they cannot provide evidence at entry that they are a qualified person under the EEA regulations, for example. Other discretionary grounds of refusal, we have two more here. One is when the applicant has been previously refused admission to the UK under the EEA regulations. It does not say under the EEA family permit, it does say under the EEA regulations, or when the EU settlement scheme has been cancelled. So those are, again, if they reapply, those are grounds of refusal again, discretionary refusal. And then the last discretionary ground of refusal that was introduced in Appendix EU a bit later on is when the applicant is a relevant excluded person, they call it. I mean, there's quite a lot of information in this slide, but summarizing, a relevant excluded person are those who may have been excluded from the Refugee Convention or from humanitarian protection. And it's basically those who are deemed to be of the subject of a particularly serious crime, and they might constitute a danger to the community in the UK. So if you suspect that someone might be a relevant excluded person, it's worth reading well Appendix EU to see whether the person falls under that definition. Now, EU 17, EU 17, basically what it says is that the references in paragraphs EU 15 and 16, so what I just told you now, to an order or decision to which the applicant is subject, okay, do not include a deportation order or decision that has been already set aside or no longer has effect in respect of the applicant. So it might be that an applicant, I don't know, sometimes applicants do not know the extent of the immigration history and the criminality history in the UK. It could be that someone tells you, I think I have a deportation order against me, and you think, oh, it could be a mandatory grounds of refusal. But maybe if you check more and you request a Home Office file, you might find out that maybe it was set aside, or it is no longer valid, a deportation order, because the person was not deported, etc. So everything I explained you about mandatory grounds of refusal will not apply on those cases. So it's good to have an awareness of the whole history of the applicant. Okay, I think now, Bella, you're going to continue now? Yes, you're going to continue now. Okay.
Okay, so I'm now going to take you through self-disclosure of criminal records and checks against the police national computer. So applicants over the age of 18 are required to provide certain information about previous criminal convictions in the UK and overseas. It is worth noting that they are only required to declare past criminal convictions that appear in their criminal record in accordance with the law of the state of the conviction at the time of their application. This includes the obligation to declare whether they have been involved in any terrorist-related activities, war crimes, crimes against humanity, or genocide. So it's important to note that there is no requirement to declare spent offences, cautions, and alternatives to prosecution, for example, fixed penalty notices for speeding. So in addition to this self-declaration, applicants are subject by the Home Office to checks against the police national computer, where the applicant is aged 10 or over, and also the warnings index. So this means that caseworkers can, where appropriate, consider evidence of criminality that they encounter on the police national computer or warning index, even if that evidence was not declared by the applicant. It's therefore very important to remember that failure of an applicant to disclose the necessary criminal records can lead to a potential refusal on grounds of deception, as Carla has discussed in length just now. This is a discretionary ground of refusal under EU 16A. So it's really important when you're working with clients to know what criminal convictions you need to declare and make sure that they are declared. So now looking at the next topic we're going on to, which is referrals to immigration enforcement. So from the information provided by an applicant and from the information obtained from the Police National Computer or Warning Index, the Home Office must determine whether the applicant should be referred to immigration enforcement for full consideration of the individual's conduct. So it's important to be aware that there are 7 scenarios where an applicant absolutely must be referred to immigration enforcement for consideration of whether they should be deported or excluded from the UK. So I'm now going to take you through these 7 scenarios one by one. So the first scenario where the applicant must be referred to immigration enforcement is where the applicant has, in the last 5 years, received a conviction which resulted in their imprisonment. The second scenario is where the applicant has, at any time, received a conviction which resulted in their imprisonment for 12 months or more as a result of a single offence. The third scenario is where the applicant has, in the last 3 years, received 3 or more convictions, including convictions that resulted in non-custodial sentences, unless the applicant has lived in the UK for 5 years or more. And in this scenario, at least one of these 3 or more convictions must have taken place in the last 12 months, and at least one of them must have been in the UK. The fourth scenario is where there is the cases of interest to criminal casework in respect of deportation or exclusion, for example, where the applicant is in prison and the case is awaiting deportation consideration. The fifth is where the applicant has entered, attempted to enter, or assisted another person to enter, or attempt to enter, a sham marriage, sham civil partnership, or durable partnership of convenience. So the sixth scenario is where the applicant has fraudulently obtained, attempted to obtain, or assisted another person to obtain, or attempt to obtain, a right to reside in the UK under the EEA Regulations 2016, and the seventh scenario, where they must be referred to immigration enforcement, is where the applicant has participated in conduct that has resulted in them being deprived of British citizenship.
So those were the scenarios wherein a case must be referred to immigration enforcement. It's also important to be aware of when a case should not be referred. This includes when
a recorded decision has been made not to pursue deportation, or a recorded decision has been made to revoke a deportation or exclusion order in respect of the applicant, and since then they have not committed any further offence that meets the referral criteria. It is also not to be referred when a previous decision to deport the applicant has been overturned on appeal, the Home Office is not appealing that decision, and the applicant has not committed any further offence that meets the referral criteria. And finally, it is not to be referred when the applicant received a custodial sentence, and at the time the applicant was in prison, the applicant's conviction did not meet the criteria for referral to the Home Office, and since then, the applicant has not committed any further offence that would meet the referral criteria. So now looking at overseas criminality, we're not going to go into this in depth here, but essentially if an applicant declares a previous overseas criminality, or the Police National Computer or Warning Index indicates that the applicant was previously extradited from the UK, subject to a European arrest warrant, or has an overseas conviction, further inquiries will be made by the Home Office. So now looking at the topic of pending prosecutions, it's also important to know about what will happen if an applicant that you're assisting has a pending prosecution. So this is something that Carla touched upon briefly earlier. So what is a pending prosecution? A pending prosecution is defined as where a person either has been arrested or summoned in respect of one or more criminal offences, and one or more of these offences has not been disposed of either by the police or the courts, or a person is subject to a live investigation by the police for a suspected criminal offence. So in this case, the application may be paused until the outcome of the prosecution is known. If paused, the Home Office will only review the application 6 months after it has been paused. At that stage, if the outcome of the pending prosecution is known, the application under the EU settlement scheme will then be considered by the Home Office. So it's really important to be aware here that where the applicant has a pending prosecution which does not meet the criteria for referral to immigration enforcement, the Home Office must consider whether it is reasonable and proportionate for the application to be paused until the outcome of the prosecution is known. It is therefore not always appropriate for an application to be paused for 6 months in all cases. For example, if the offence is very minor and it will not affect whether the applicant meets the suitability criteria, the application shouldn't be paused by the Home Office and they should consider it. So if you're assisting someone where you think their application may have been paused and you believe it is not reasonable or proportionate for this to happen, you may want to consider submitting representation to the Home Office about this issue and noting that it shouldn't be paused in their scenario. Finally, if you come across an applicant who receives a refusal on suitability grounds, it's important to know that anyone who makes a valid application under Appendix EU on or after 11 p.m. on the 31st of December, January 2020, will have a right to appeal against the decision to refuse the application on the eligibility or suitability grounds. And they may appeal on grounds that the decision breaches any rights they have under the withdrawal agreement or the other citizens' rights agreements, or that the decision was not in accordance with the immigration rules under which the decision was made. So I'm now going to pass you on to Carla, who will provide an introduction to working with people with criminal convictions.
Thank you, Bella. So the part that we're going to start now of the training is more like we're going to be looking in practice how to help those who actually have criminal convictions. So, and this is the second part of the training. Okay, so it's important, or we think that it's important to discuss about this particular group of applicants because some aspects of the Home Office policy surrounding suitability and criminality remain unclear. For example, what type of offences should be disclosed, how prisoners should apply under the scheme, etc. And also it's important to discuss about this group because applications can and will be refused on suitability grounds. And also you must be aware of the possibility that the applicant will not only get a refusal possibly, but in the meantime maybe also referred to immigration enforcement, and that can lead to another issue, which is deportation proceedings. So it's why it's important to have like all of that very clear when advising people with criminal convictions. So the common issues that we have encountered working with persons with criminal convictions are the following. The 6 issues that we have encountered are, first, many applicants have a complete lack of knowledge of the criminal records or of the full history. Second, the self-disclosure requirement sometimes is not too clear for many applicants. Now, how imprisonment and continuous residence interplay, so that's another thing we need to discuss. Another common issue are referrals to immigration enforcement and how they work, refusals, and also we're going to touch on briefly on children and those who have children that have criminality issues as well, how to deal with the application. So, lack of knowledge of criminal records. So, if you encounter someone who do not know the extent of the criminal records in the UK or abroad, or if they don't know whether their convictions have been spent, because Bella mentioned, applicants are not required to declare spent convictions. So what there is not too clear. One of the things that you can do in practice to help the applicant is to actually take a copy of the criminal records in the UK. Those criminal records are held in the police national computer, and that will give you a better picture and more clarity about what needs to be disclosed and what's the situation of that applicant. To make this subject access request to the Criminal Records Office, it's pretty easy to do it. All you need is the applicant's proof of identity, and that includes driving license or a passport. And if the applicant doesn't have any of those documents, they also will need to provide authentic documentation to the Criminal Records Office to verify the full name and date of birth. In order to make this request, if you're helping the applicant directly to do it, you also will need to be, you are asked basically to disclose the last 10 years of the applicant's addresses in the UK. Now, that can be a bit tricky sometimes because applicants might not recall all the addresses on the last 10 days, or 10 years, or maybe they haven't been here for that long. So in practice, what we are normally doing for those applicants is that we are stating a different address, for example, their current address, and then mark that they've been here in that address for the last 10 years. And then when you continue the application form, at the end, there is a box where you can add more information. So on that box, we then explain that the applicant cannot remember this information, and it's normally fine. The request goes through and we get the criminal records back. That is quite relevant, especially if you are helping those who have criminal convictions and also homeless individuals or have like severe mental health issues. Like it's very often with these individuals, they will not remember the extent of all the addresses they lived in the last 10 years. In order to make the subject access request, of course, if you're doing it directly for the applicant, you will also need a letter of authority signed by the applicant, giving you authorization to make this request, and also to receive the police national computer records, which you can receive in your own email if you have authority. And you will need to, as we said, provide full identity of the person that is applying for the criminal records. You can do this request online or by post, but it's normally much easier to do it online. And if you do it online, all you have to do is to provide a valid email address, which can be yours if the applicant authorizes you to do so. And you will then receive the records online via email. Just as a practical tip, if you start the online request form, you will not be able to come back to this page without losing all the applicant's details entered. So you will have to start again, and also the form will time out after 60 minutes of inactivity. The request is completely free. You don't have to pay anything for it, and it normally takes 1 calendar month. Sometimes we see subject access requests coming before that, but normally it's 1 calendar month. And the result, as I said earlier, can be received by email very easily, and it's much easier to do everything online. With regards to the issue of whether someone's criminal record, criminal conviction is spent or not, unfortunately that information will not be held in the police national computer. And to know that, you will need to actually confirm this with a criminal solicitor. There's different ways to calculate when a criminal conviction is spent, depending on how serious it is, how many years has been in prison that person, etc. So there's a specific, this is specifically regulated in the Rehabilitation of Offenders Act. So that this piece of legislation gives you the parameters of when, to understand when a criminal conviction has been spent or not. But if you're not too clear, you might need to confirm that with a criminal solicitor, because you don't want to provide false or misleading information by not declaring something that the applicant should be declared and then be refused on discretionary grounds because you didn't disclose it. Okay, so that was all about lack of knowledge of criminal records. Now, moving on into the self-disclosure of criminal records. So all applicants, without exception, over the age of 18 are asked to declare their criminal convictions, and they're asked to declare those who appear in the criminal records, so that they're not spent, in the UK or overseas. And as Bella mentioned, they don't need to declare spent convictions, cautions, or alternatives to prosecution. So again, important to check the PMC record, because it might be that the person only has been issued with cautions and that's it. So there's nothing to declare. Now, in order to help you to prepare the application, these are the type of questions that the applicant will be faced with. So the question is, have you ever been, and then it says, convicted of a criminal offense, arrested or charged with an offense that you are on trial or waiting trial, and this includes in the UK or any other country. And then the second question you encounter is, have you been convicted of a criminal offense in the UK in the last 12 months? So to reply to this, of course, you need to know the extent of the criminal convictions of the person. Now, there are more questions on criminality under the EU settlement scheme. They also ask you, have you had a criminal conviction outside the UK that involves any of the following? So, and here's important to look at this question properly, because they're only concerned about criminality outside the UK that involves a violent offense, a drug-related offense, or a prison sentence of 12 months or longer. So a lot of times we encounter individuals that are here for good that do not tick any of these three boxes, and we do not disclose criminal records because it doesn't seem to be in any of these categories. So again, we need to look properly when it comes to criminality overseas. And of course, they also ask if the applicant has been arrested or charged for an offense for which they are currently awaiting trial. So if they're awaiting a criminal trial, they will be asked so. And finally, all applicants are asked if they have been they have ever supported, encouraged, or been involved in terrorism, war crimes, crimes against humanity, genocide, and extremist organizations. If they are, they probably will fall under discretionary grounds of refusal. They might be relevant excluded person, for example, if they've been removed from the Refugee Convention as well. Okay, so that was all about self-disclosure. Now, talking about imprisonment, this is like a common question sometimes. Applicants might have been living in the UK for a while, and they have maybe built their family life, all the professional life, etc. here, but they have served some time in prison in the past as a result of a criminal offense, and they might struggle sometimes to understand whether, one, can they apply under the scheme if they've been in prison? And secondly, how is this criminal conviction and criminal past history, how is this going to impact in terms of accruing those 5 years continuous residence in the UK? Is time spent in prison counting towards those 5 years? So this is a common question, and it's why we're covering this now. So the basic rule is that a continuous qualifying period might be broken. It doesn't say must, it says might be broken, where the person served or is serving a sentence of imprisonment of any length in the UK. So time in prison breaks that continuity of 5 years qualifying period. However, if a prisoner, prior to the criminal sentence, have already acquired permanent residence under EU law, and it does not matter if they apply to for a permanent residence document. Remember, under EU law, it's not mandatory to apply for documents. But if that person exercised treaty rights for 5 years and they acquire permanent residence, they should then be in principle granted settled status under the scheme, as long as no supervening event has occurred since they last acquired this permanent residence. Okay, so not always and automatically a sentence of imprisonment will break continuity. It all depends on what happened before going to prison and whether that person already accrued time of residence in the UK that is relevant under the EU settlement scheme. Now, if a prisoner prior to this criminal sentence has not acquired permanent residence, then of course this continuity of residence is broken, and they then might be granted pre-settled status under the scheme if eligible. Okay, so first, immigration enforcement. So if the application is referred, as Bella told you earlier, what are the triggers that can lead to a referral to an immigration enforcement team? If the application is referred, the applicant will be sometimes, not always, but where relevant, they say the guidance, be contacted and submit also representations as to why they should not be deported. So the application is referred to the immigration enforcement team. The immigration enforcement team look at whether there is any interest on deporting that person. And if it is, then they might be then engaging with the applicant so that the applicant can submit representation explaining why they shouldn't be deported or excluded from the UK. Now, the guidance says that immigration enforcement team will carefully consider the circumstances of the case and will take into account any submitted representations by the applicant or by you or by whoever is helping the applicant with the application. Now, where the relevant test for deportation or exclusion is met, the Home Office then will inform the applicant that actually deportation proceedings will be issued against the applicant, and they probably will issue a separate letter refusing the EU settlement scheme application. So if they decide, the Home Office, no, there is an interest on deporting that person, we're going to issue a deportation order or a decision to make a deportation order, they will then, two things will happen. First, they will send that decision to issue the deportation order to the applicant. Parallelly, because they are issued with a deportation order, this will trigger a mandatory grounds of refusal, and therefore the EU settlement scheme also will be refused. Okay, now, but that is only when the relevant deportation test is met, and we already talked that the test is different. EU law test is one, and domestic UK, domestic deportation law is a different type of test. And it depends on when the criminal conduct happened. If it's before or the end of the transition period, different tests will be applied. Now, where this relevant test is not met, so the person offense is not serious enough, etc., then they will simply be granted settle or pre-settle status under the scheme. The problem with referrals to immigration enforcement is that we don't know when this is happening. So unfortunately, the Home Office does not notify the client, does not notify the solicitor when this referral is happening. And you don't know all of the assessment that is happening. You don't know anything. All you know is at the end of the day if the application has been refused or not, and whether deportation proceedings have been issued. But in practice, what we encounter is like loads of applications might be pending because of this referral. So the referrals to immigration enforcement might make the applications to take longer to be processed. And again, this could be challengeable as well. You need to check whether there is any perspectives of that person's case to be, if there's any likelihood that that person can be deported or not, because if you know from the beginning that the criminality, it does not meet the test, there's no reason then for this referral, or there's no reason to pause it for a long time. So you need to scrutinize in every case what is happening. But this referral will happen if certain triggers are there, but then you might be able to challenge how long is with the team, etc. Okay.
So now looking at the next practical issue, which is dealing with applicants that are concerned their application under the scheme may be refused on suitability grounds. It's very important to remember that applicants with criminal records are often very anxious about the outcome of their applications, especially when they have built their life in the UK. You must always inform an applicant that if they meet the relevant criminality thresholds, their application can be referred to immigration enforcement, deportation action can be initiated, and they may be refused on suitability grounds. In addition, if the applicant was submitted on or after 11 p.m. on the 31st of January 2020, as I mentioned earlier, you can inform the applicant that if their application is refused, they may be able to challenge the decision in court, as they will have the right to appeal to the first-tier tribunal. Such a case would be needed to be handled by a very experienced and senior immigration advisor or solicitor, so you may need to refer it on at that stage, depending what level of immigration advisor you are. So you can also tell them that if the Home Office decides to issue deportation proceedings against them, or if their status is revoked as a result of a deportation decision, they will also have a chance to challenge these decisions by submitting representations and lodging an appeal to the first-tier tribunal. So again, this is a situation where the case would need to be handled by a very experienced senior immigration advisor or solicitor. And finally, the last issue that we're going to look at is children with criminality issues. So in regard to the requirement of self-disclosing criminal convictions, which we discussed earlier, the EU Settlement Scheme Suitability Guidance exempts children under the age of 18 from declaring criminal convictions in their applications. However, applicants over the age of 10 are subject to criminal record checks. So it's worth noting that with regards to children, EEA law has provided that any refusal of settlement status to children on grounds of conduct must be absolutely exceptional, based on imperative grounds of public security and when it is in the best interest of the child. So there are these additional protections in EEA law for children. However, at present, the Home Office published guidance on the EU settlement scheme lacks clarity as to how precisely the suitability criteria and threshold of criminality applies to children. Moreover, the guidance fails to explain that the threshold for suitability is higher for children than for adults. So, acknowledging this lack of clarity, when you're assisting a child that does have a criminal record, we therefore recommend taking the following approach. If a child has committed a criminal offence that will not be an issue under the suitability requirements, there is no need to declare it, as they are not required to do so if they're under the age of 18. and it will not have any impact on the success of their application. However, if you're concerned a child has committed a very serious criminal offence or could be considered a persistent offender, and there may be an issue in relation to the suitability requirement, we would recommend submitting detailed legal representations explaining why the child's criminal behaviour should not have any impact on their application under the EU settlement scheme. And such a case would often need to be handled by a very experienced and senior immigration advisor or solicitor. So again, you may want to refer it on in that situation, depending on your level. So that's actually the end of the training part of our session for today. So we're now going to take a 5-minute break. So go grab a coffee or a drink, and then we'll come back and do the case studies.
Hi, everyone. Okay, I'm going to wait for Isabella and okay, great.
Hi, Carla. Great. So shall we have a look at the first scenario?
Mm-hmm. Great. So this is case study 1, and we're just now going to give you some time to read through the facts on this slide and also think about the answers to the 2 questions that are posed in blue at the bottom of the slide.
Okay, so you had now a few minutes. I'm going to just summarize briefly the case study 1. So basically, we have here a Portuguese citizen born in 1980. Petra is her name. She came here in the UK in 2005, but then she returned to Portugal in 2010. So she completed 5 years residence in the UK. However, she then returned to the UK in January 16. So she spent 6 years abroad. And since then, she's been working in different cleaning jobs. And she has various criminal convictions in the UK, as you can see here. She was sentenced in August 18, in October 19, and in January 20. Now, she came to your organization because she is, of course, concerned about her criminal convictions. Some of them happened quite recently. And she also wants to understand whether she should apply for settled or pre-settled status, given that she already completed 5-year residence in the UK. So now is the moment, if any of you would like to answer those questions. If you prefer it, you can write it in the chat, or if not, just unmute yourself and you can contribute to the discussion. Anyone want to say anything? What do you think? Do you think should apply to
Hi. I just think that she had recently committed 2 times crime, in a short period of time, because it's now 2020-21 is coming, and then basically she committed twice the crime. The one crime is actually quite serious because she offended an NHS worker, like a public servant, like sort of. And also, she had the 5 years gap in between the time she'd been in UK 5 years, but has she claimed the UK residence by then? Has she got the residency identity card? That would be my question, because I'm not sure. It doesn't state it.
Okay. So do you think she should apply for settle or for pre-settle?
If she has the set of the residency card, then she will be applying for the settled, because some people already may have that card.
You mean the permanent residence card?
Yes.
Okay. Okay. So in regards to that, it's good that you touched this, because we haven't actually touched in what the scenarios you could lose permanent residence. But say if she acquired permanent residence and she had the card, that the permanent residence was lost, if then the applicant left the UK for a period of up to 2 years. So in any case, she lost that right of permanent residence if she acquired it from 2005 to 2010. You can see here the difference between permanent residence and settled status. They're similar rights, but actually settled status gives you more, is more generous, because it allows you to leave the UK up to 5 years without losing it. Permanent residence only allowed you 2 years. So she would have lost it anyway, the permanent residence document. So in any case, yes, because she came back in January 16, she's now only eligible for pre-settled status. Pre-settled status. She can wait if she wants to and apply in January 2021 for settled status directly. Is up to her. Now, you also mentioned the criminal conviction. I guess. Can anyone else identify the key issues? It's probably right, and it is probably the absence from the UK and the criminality. Let me check out the chat. Yes, so Nagulan said no eligible. Yeah.
Can I also mention there is another thing about her job, because it was mentioned she was a cleaner, whether she was registered paid cleaner, or did she work for cash in hand as a self-employed? Has she got paid? Has she paid enough tax? Or it's also, this is not clear as well.
Do you mean that this will be relevant when she applies for settled status?
I think I met actually several people. They have cases of problems, like because of they've been self-employed, some of the people who I've been talking to, and they have gaps in between because they've been self-employed.
Okay. And do you think that if she was working cash in hand, do you think that she would qualify under the scheme?
Definitely not.
Okay. I mean, she could actually qualify because basically under the EU settlement scheme, you don't have to be doing any economic activity anymore. And again, this is a major difference with permanent residence document. This is a major difference between EU law, the old permanent residence, and the EU settlement scheme. So
okay.
Under the EU settlement scheme, it's more generous, not only because it gives you 5 years, you can live maximum without losing it, but also it does not require you to do any economical activity in the UK for you to have the right of settled status. It's all based and solely based on residence. Have you been here? Can you prove that you've been here? Now, problem is, if you have been working cash in hand, if you have not maybe renting an accommodation, or maybe the rent is not under your name, if you don't have like a bank account, all of these things will make it very difficult for the applicant to show that residence in the UK in the last 5 years. Then it becomes problematic. But if she could show through bank statements that she's been in the UK for 5 years, it doesn't matter what she was doing during those 5 years. I mean, apart from if she was committing criminal offences, that of course will then maybe lead to a refusal, but on suitability grounds, not on eligibility. So she will be eligible for the sole reason that she's Portuguese and resident in the UK. But yeah, that sometimes gets confusing, and a lot of people call here for good, very anxious, thinking, well, I haven't been working for the last 3 years, so I might not qualify. Wait, if you've been in the UK, that's fine. It's all you need, residence. Okay. Anyone else want to say anything else about this before I move on? I mean, here we can see already in the last paragraph that she has a biometric Portuguese passport. So we're good here in terms of eligibility and showing her entitlement to apply. And HMRC records for the last 4 years. So let's go into to check a bit more about this. We already covered at this point, she's eligible for pre-settle, but in January 2021, she might be eligible for settle. And she seems to meet the eligibility requirement. She's a Portuguese national with a passport. But that criminality might lead to a refusal. I don't think so in this type of case, but it could be. Tip. We already covered this. You already covered it yourself. It doesn't matter those 5 years that she lived in the UK because, unfortunately, she left to Portugal for 6 years. So she lost that right that she possibly accrued in the past. Now, here, when we advise her, apart from telling her, look, this criminality might lead to refusal, you also have to tell Petra that actually her case might be referred to immigration enforcement. And it's likely that this is going to happen. Because basically she has lived in the UK for less than 5 years, and in the last 3 years she has received 3 or more convictions. And as Bella mentioned when she went through the triggers of immigration enforcement, this was one of those. 3 criminal convictions in the last 3 or more convictions in the last 3 years, I think, when the person has lived in the UK for less than 5 years. So definitely this case will go to immigration enforcement. Different issue will be if she meets another deportation threshold, which that would be another piece of advice that you can give her if you're qualified, but the referral might happen. And then we have the suitability assessment. So as part of this referral to immigration enforcement, the case will be assessed and that suitability will be looked at. And of course, that can lead to a refusal potentially. Now, in terms of potential referral to immigration enforcement, I think what you need to tell her as well to Petra is that if the case gets referred and if deportation proceedings are issued against her, then as soon as a deportation order is enforced against her or a decision to make a deportation order, that EUSS application might be refused on mandatory grounds of refusal. So you can't have a deportation order and apply in the scheme because that is a mandatory grounds of refusal. So that is something that you might need to explain her as well.
Sorry, I don't understand now here.
Yes.
Basically, she can't be deported or she can be deported and she can't reapply. I don't understand the English, sorry.
No, it's totally fine. And also right. Native speaker. So
no, it's it's quite you're using professional terms, you know. And yeah.
So Petra's case is referred to immigration enforcement. And immigration enforcement decides, very unlikely in this case, but decides that she meets the EU law threshold for deportation and decides to issue a deportation order. That is something that she will need to be challenging specifically with the solicitor because it's a deportation proceeding. But this will trigger a refusal under the EU settlement scheme. Because if you remember, you cannot be granted settle or pre-settle status under the scheme if you have a deportation or exclusion order against you.
Okay.
Is that clear?
So that means she will be refused anyway, yeah? She
will be refused anyway, yeah. If she's issued with a deportation order, she's going to be refused.
No, there is no point.
If she's given a deportation order, no, if she's referred to immigration enforcement.
Okay.
Because most people don't.
And how would be the date?
Wait, I lost you.
If she was married, can you hear me?
Yes.
Hello.
Yeah, now, yes, Susanna, yeah.
She was married, sorry about that, my internet connection. If she was married, her husband never committed any crime, and he was ordered set of status.
Yeah.
So you should go underneath, isn't it? Like if they had kids together. That would be different scenario.
Well, yes and no.
If you had a kid who never committed.
Yeah. So Susanna, yes and no is the answer. To answer this, we need to go to the deportation law, okay? Because for the Home Office to make a decision to deport someone, they need to look at loads of different parameters. It's quite a big decision, okay? Because this decision excludes someone from the UK and bans they re-entry for a long time. Oops, I don't know if, are you talking at someone? Okay, so it's a very important decision made on the immigration law to make the decision to deport someone. So when the Home Office make that decision, they will be looking at many things. They will be looking at Petra's criminal convictions in the UK and whether they are serious enough that the threshold for deportation is met, but also as part of the deportation assessment phase, they will be looking at other things in her life. They will be looking at whether she's married, at whether she has children, at whether she has like mental health issues, or whether she cannot leave the UK because she is under medical treatment. So all of these things will be assessed on that decision to deport someone. But this is not EUSS related, it's more about deportation law and how the Home Office make decisions to exclude someone from the UK. And this decision to exclude someone from the UK, different parameters will be looked, whether it is under EU law or under UK law. If Petra's criminal convictions happen all before December this year, it's all going to be EU law. EU law is what is going to be applying. But if her criminal conviction is after the transition period, then we are going to be looking at UK domestic law on deportation. But this is slightly separate from the EUSS. It's something that might happen parallelly. I don't know if I answered your question. It's a little bit difficult when it comes to deportation.
Yes, thank you.
Okay. So that would be this, the potential referral. Also, her application could also be refused on discretionary grounds, as we said, because she received in the last years those convictions, etc. Okay. And that's exactly what we covered already. So the UKVI will refer her case to immigration enforcement because she is the type of criminality triggers that immigration enforcement referral, but then they will consider whether it issue deportation or not. They might not do it, and I'm sure that a lot of cases get referred and they don't do anything, but it gets referred, and you don't know if that happens. And if a deportation order was made separate from the EUSS, she will then be able to challenge it. She will need to hire solicitors. She might be able to appeal that decision, etc. Okay, but this is a different legal order, deportation. Okay, yeah, we already covered this. Sorry, some slides are a bit repetitive, I'm realizing now. Okay, so if your level of accreditation allows you to provide advice on this matter, I'm not sure if you can provide advice on deportation or criminality sometimes, depends on your level of accreditation, but there's two options we think here in this case. You can apply now. If she really, really wants to apply now, she can apply now, being aware that because the last criminal conviction happened in January, so that is in the last 12 months, her case will be referred to immigration enforcement 100%, so the case will be referred to immigration enforcement. So as long as she's happy that that referral will happen and she's fine with it, that's fine, you can apply now. You could also make representations helping her in a cover letter, setting out why this referral, yes, you can make it, but it might not be appropriate because in any case, her case will not fall under deportation proceedings, for example, but again, you need to be accredited to do so. And this option A is, for example, important if she wants to apply now, if she can't wait, and if she needs now her right to proof of her right to reside, or whether if she intends to travel in the near future. So it really depends on the circumstances of Petra that you might wish to apply now, or knowing that the deadline is not until June 2021, you might prefer to tell her to wait until at least 12 months have passed since her last conviction, and that would be January 2021. That means that then that referral to immigration enforcement will not happen because it will not be on the list of cases that needs to be referred to immigration enforcement. And it could be more straightforward doing it this way as well. So different options depending on calculating convictions is important to check that as well. Suitability. We already said that. So as part of that suitability assessment to see whether they want to refuse her EUSS application, they will be looking at her previous criminal convictions. We said that. Okay, so Petra should know that all her criminal convictions will be taken into consideration, but any decision to deport her, as I just said to Susanna, will depend on a proportionality assessment, and the Home Office will be looking at many things, not only the criminal conviction, also how long she's been in the UK, family links, etc. And the test will be, in this case, will be the EU law test of the policy and public security test as set out in the EEA regulations, because this criminal conduct happened before the end of the transition period. If you are helping her to do covering letter, what you should say? Well, you should set out Petra's background, family life in the UK, why she should be eligible for pre-settled status, this is if she applied now, and the reasons why the referral would not be appropriate, because she doesn't meet the referral for the threshold for deportation. That would might help her case. Okay, we now have a second case study. Again, we're going to give you like 3 minutes because we want to give you some time for discussion at the end. So just really quickly, and Bella will go through, and then we take some questions.
Okay, great. So due to time, I'll just run through the facts with you now. So we have Philip, who is a Polish citizen. He moved to the UK in July 2017, looking to improve his economic situation. He went to live in Scotland as he had a friend there who knew someone who could offer him a job. He worked for a few months in a building site where he was paid cash in hand. However, after a year, due to alcohol dependency and mental health issues, he lost his job and became homeless. At the beginning of the year, Philip moved to London. He is currently receiving financial and housing support from a homeless charity. Philip mentioned during an appointment that he had pending criminal proceedings in Scotland. Apparently, he was released on criminal bail on the 15th of November 2019, and he has a criminal trial listed for November 2020. He does not know the exact nature of his criminal offence, but thinks it was related to an incident that he had one night in the street whilst he was drunk. He does not have any further details of his charges or any paperwork regarding his criminal case. The only thing that he can provide you with is a business card of the legal aid criminal solicitor based in Scotland that helped him to obtain criminal bail. Philip does not speak English and requires the help of a Polish translator. He has a biometric Polish passport. So, the questions are, as you can see on the slide, is Philip eligible for pre-settled or settled status? And what are the key issues in this scenario? So if anyone wants to unmute themselves, or they can write in the chat box as well. Great. Yep. So a few people have written that he is eligible for pre-settled status, and that the key issue is the pending criminal proceedings. Yep, and lack of knowledge about these. Exactly. Okay, so if we go through the slides now. So as you've identified, a few of you have identified in the chat box, Philip may be eligible for pre-settled status, and that's because he has lived in the UK for a period of less than 5 years, and he meets the eligibility requirements. However, there's a possibility that Philip may still face an issue with the suitability requirement. So if we go on to the next slide. The issues to look at, as many of you have identified in the chat box, are the pending criminal proceedings. So Philip has a pending criminal trial in Scotland listed for November 2020, which he knows very, very little about. And also, then the other issue we could see raised in this scenario is that Philip cannot speak or read in English. It is therefore very important that there is a Polish interpreter at your appointments with him so that he understands your legal advice. Right, so looking at the pending criminal proceedings, we know that Philip doesn't have any information, really, regarding his pending criminal proceedings in Scotland, and you will need this information to help him with a potential application under the EU settlement scheme. So the first step will therefore be to contact his criminal solicitor in Scotland to find out more about the nature and extent of the criminal charges he is facing. We know from the scenario that he has his solicitor's business card, and therefore you can use this to contact them. This will help you gain clarity regarding his criminal case, because it could be, for example, that either he has a very, very minor offence or potentially a more serious conviction that he is about to go on trial for, and you really need to find out what this offence is. So, at this point, we do not know whether Philip's trial will result in imprisonment. We would generally advise that if you find out that Philip is on trial for an imprisonable offence, you submit the EU settlement scheme application in advance of his criminal trial. This is because, at the moment, it is very difficult for individuals who are in prison to submit applications under the EU settlement scheme. While it is legally possible for them to apply, in reality, there are big practical barriers for them doing so. When completing Philip's application, you should make sure that you answer the following question correctly on the online form. So the question is, have you ever been convicted of a criminal offence? In this case, no, Philip hasn't, but he has been charged with an offence that he's awaiting trial for. So the answer to this question on the online form would be yes. Now, once you submit the application, the Home Office may decide to put the application on pause due to his pending criminal trial. It is very important to remember that the EU settlement scheme guidance states that the Home Office must consider whether it is reasonable and proportionate for Philip's application to be paused until the outcome of the prosecution is known. So, as I discussed earlier, if you find out that the trial is for a very minor offence that would not cause a referral to immigration enforcement or any issues in the applicant meeting the suitability requirements, there would be no justifiable reason for the Home Office to put an application on pause. This is particularly important to be aware of if the trial is a long time away, because you don't want the application to be paused unnecessarily for that time. In such a situation, you could write legal representations to the Home Office setting out why the application should not be paused. In situations where the trial is coming up soon, such as Philip, where the trial is next month in November 2020, it is also important to remember that as soon as you know the outcome of the trial, you should inform the Home Office that the prosecution is no longer pending, and so the application should not be paused and they should make a decision on it as soon as possible. The reason it's important to do this is that, as noted earlier on in the training, if the Home Office do put an application on pause as a result of a pending prosecution, they will usually only review it again after 6 months. And therefore, if the prosecution is finished, you should inform the Home Office of this so that they are not unnecessarily waiting until 6 months has passed before reviewing and processing the applicant's application. So then, in terms of the language barriers issue, as I mentioned, it would be important that you have a Polish interpreter available for all oral and written communications with Philip so that he fully understands his position, what he is applying for, and the situation surrounding his criminal trial. Okay, so that's the end of our training for today. We are now going to move on to a Q&A for those of you who are watching live. For those of you who are viewing this recording at home, thank you very much for watching our webinar. We hope that you found it useful. Please feel free to refer to our detailed training manual if you want to look back at the written solutions to the case studies or refresh your memory on anything you have learned today. Thank you very much and goodbye.
Goodbye, everyone.